Hi everyone, myself Hasini from degree second year. Today I am gonna explain about preventive detention, which was recently in news. First thing, why is it in news? Actually, recently Supreme Court gave a judgment on this preventive detention that it should be used in rarest of the rare cases because colonial legacy has been misused and also it gives extreme powers to the state governments. So Supreme Court stated that protection of individual and civil liberties is the utmost importance of the Constitution. First thing, what is preventive detention? Actually, there are two detentions. One is punitive detention and another one is preventive detention. Punitive detention is arresting an individual after the commission of the crime. Coming to the preventive detention, it is arresting an individual before the commission of the crime. Its purpose is not to punish the person or individual for his or her past offense. Preventive detention cannot be extended beyond 3 months. In case of extension, it should be presented before the advisory board comprising of High Court judges. And the person who is arrested under preventive detention should give every opportunity to represent before the board. Preventive detention is mentioned under Article 22 of Clause 4 and Clause 5. Article 22 Clause 4 deals with the person who is arrested under preventive detention should provide a legal practitioner of their choice and also should inform for the detention. Coming to Article 22 Clause 5, it says that government should maintain records of all detentions and should be presented before Parliament. It is mentioned under even state and union subjects. Under entry number 9 of union list, it says that even Parliament has passed to make laws under preventive detention on the matters related to defence, foreign affairs, security of India. Next, entry number 3 of concurrent list, it is mentioned that both state and parliament has passed to make preventive detentions on the matters related to security and maintenance of essential services. Dr. B.R. Ambedkar gave his statement on preventive detention that India like a complex country and India should need stringent laws like preventive detention for control of the crimes. Actually, preventive detention is highly controversial, so there are some issues associated with this. Some of them are, it violates Article 20, like preventive detention didn't mention any provisions for torture. So it violates Article 20, Article 14, Article 21, Article 19, etc. And it also violates social justice. Recently, Mr. Bandi Sanjay and T. Raja Singh, who is BJP MLA, was arrested under preventive detention. But as per Article 4 of ICCPR, International Covenant on Political and Civil Rights, under this, preventive detention should be used only on times of national emergency, which threatens the life of the nation. So here, it clearly shows that it is a violation of Article 4 of ICCPR. There are important judgments under preventive detention. First one is A.K. Gopalan versus State of Madras, 1950. Supreme Court stated that preventive detention didn't violate any fundamental rights and it also followed all safeguards mentioned under the law. And next case is about Ram Manohar Lohia versus State of Bihar in 1965. Under this case, Supreme Court stated that preventive detention laws are valid on the grounds of security of state, law and order and maintenance of public order. So to conclude this, definitely preventive detention laws are enacted in order to prevent antisocial elements from causing harmful effects on the society. But these laws have to be applied with utmost care to avoid controversies. We can anticipate mains questions on this topic. They may ask on constitutional safeguards and issues associated with preventive detention and opinionated questions like, do we need preventive detentions in India? Thank you.